If you're a green card holder, a visa holder, a naturalized citizen, or someone waiting on a petition that could change your family's future, today's breaking headline may feel like it belongs in another world. Canada invoking NATO consultations, shockwaves across Washington, diplomatic tension between two of the closest allies in modern history. It sounds distant, strategic, military. But here's what you need to understand clearly and calmly. Whenever security relationships between countries shift, border enforcement posture shifts with them. And when border posture shifts, immigrants feel it first. There has been no announcement of new immigration bans. There has been no cancellation of green cards. There has been no termination of visa programs. But when a close ally signals that it feels threatened and security consultations begin, agencies like DHS and CBP review protocols immediately. That does not mean panic. It means heightened scrutiny. And heightened scrutiny affects how officers evaluate travel, documentation, and intent. So let's separate fact from noise. Canada has formally requested NATO consultations under Article 4. That is a diplomatic mechanism. It is not an immigration statute. It does not rewrite U.S. immigration law. But moments like this often trigger internal reviews inside American agencies. Intelligence coordination, defense communication, and cross-border data sharing may be reassessed. And when agencies reassess cooperation, they reinforce screening standards. If you regularly travel between the United States and Canada, you may experience more detailed questioning at entry. That is the most immediate and realistic impact. For green card holders, the key issue is always intent to reside permanently in the United States. If you spend extended periods in Canada, especially months at a time, officers may ask additional questions. They may review your travel history, they may ask about your employment, your home address, your tax filings, and your ties to the U.S. None of that is new, but during periods of diplomatic strain, officers are less likely to overlook inconsistencies. If you are a lawful permanent resident who works remotely from Canada for extended stretches, you should be careful. Permanent residence requires maintaining the United States as your primary home. Long stays abroad without a re-entry permit can raise abandonment concerns. Even if Canada is friendly, even if you own property there, even if your family is there temporarily, the standard is not emotional connection. The standard is residency intent supported by evidence. If you are planning travel for family reasons, medical emergencies, or business, prepare documentation in advance, carry proof of U.S. residence, lease agreements, mortgage statements, employment letters, tax transcripts, school enrollment records for children. Officers make decisions based on documentation, not explanations alone. For visa holders, particularly TN, H-1B, F-1, or B-1, B-2 travelers moving between the U.S. and Canada, compliance must be clean. Your visa category must match your activity. If you are on a student visa, ensure your I-20 travel signature is current. If you are on H-1B status, carry your approval notice and a recent employment verification letter. If you are on TN status under USMCA, make sure your employment duties align precisely with the profession listed. During geopolitical tension, officers may scrutinize category alignment more carefully. For naturalized citizens, your citizenship is secure. Diplomatic disputes do not undo naturalization. However, if you are sponsoring relatives through Form I-130 or are involved in family-based immigration cases, background checks can slow during periods of interagency coordination shifts. That does not mean denial. It means patience may be required. USCIS relies on security checks conducted through multiple agencies. If defense resources and intelligence teams are temporarily redirected due to global consultations, processing timelines can stretch. This is procedural. It is not punitive. Let us talk about how enforcement feels in real life. At airports, CBP officers may refer more travelers to secondary inspection. Secondary inspection is not an accusation, it is a review. But during global instability, officers may use it more often. You may be asked about prior travel patterns, you may be asked about employment, you may be asked about digital devices. Stay calm. Answer directly. Do not guess. If you do not know an answer, say so. The most common mistake immigrants make in tense political climates is over-explaining. Keep answers focused on the question asked. If you are adjusting status and have advanced parole, ensure it is valid for the full duration of your trip. Re-entry under advanced parole is discretionary. Officers verify that your underlying application remains pending and valid. If you leave the U.S. for extended periods while adjusting status, that can create complications. If you are a conditional permanent resident preparing to file Form I-751, avoid long travel unless absolutely necessary. Conditional residents often face closer review because their status is time-limited. During heightened enforcement awareness, officers may question extended absences more closely. Students should verify that their CVIS records are accurate and that they are enrolled full-time unless properly authorized otherwise. If you are on STEM OPT, ensure your employer remains E-Verify compliant and that reporting requirements are current. security tensions sometimes bring additional review to technical and defense-related fields. If you are applying for naturalization soon, double-check your physical presence calculations. Officers compare your travel declarations against CBP entry-exit records. During sensitive geopolitical moments, inconsistencies are more likely to trigger follow-up questions. It is also important to address rumors directly. There has been no confirmed suspension of U.S.-Canada border crossings. There has been no order revoking visas based solely on nationality connected to this dispute. There has been no cancellation of immigration categories tied to NATO discussions. What exists is diplomatic consultation. However, border agencies operate on risk management principles. If intelligence sharing changes or becomes temporarily strained, officers may compensate by increasing direct questioning. If you are someone who holds dual ties and spends part of the year in Canada and part in the U.S., be especially mindful. Permanent residence requires consistency. If your center of life appears to shift north for extended periods, officers may question your intent. A re-entry permit is designed to protect against abandonment concerns for absences longer than 1 year. Use it when necessary. For employment-based applicants whose companies operate in both countries, ensure that your job location aligns with your petition. Working outside the listed location without proper amendment can create compliance issues, especially if reviewed during heightened scrutiny. Family emergencies are real. Travel happens. The key is preparation. If you have a pending case, ensure someone in the U.S. can receive mail. Missing a request for evidence because you were abroad can delay your case significantly. For sponsors submitting affidavits of support, keep income documentation current. Economic volatility connected to geopolitical tension can affect employment stability. USCIS reviews tax transcripts carefully. Accuracy matters. Let us also talk about tone at the border. Do not discuss political opinions with CBP officers. They are evaluating admissibility and compliance, not ideology. Keep responses factual. If asked about travel to Canada, explain purpose clearly. If asked about employment, answer consistently with your petition or visa category. If you previously overstayed but later adjusted status lawfully, carry documentation showing your approval. Officers see history in their systems. Organized paperwork prevents confusion. During moments of international tension, cybersecurity and background checks may also expand slightly. If you work in technology, defense, or research fields, ensure your employment authorization remains current and properly documented. Avoid working outside authorized duties. For visa applicants waiting abroad, administrative processing can sometimes lengthen if additional security checks are introduced. That is frustrating, but it is not uncommon during global uncertainty. Plan accordingly. Green card holders considering relocating to Canada long-term because of uncertainty should understand the legal risk. Permanent residence requires maintaining the United States as your primary home. If you intend to live outside the U.S. permanently, that may jeopardize your status. Structure travel carefully and consult qualified professionals before making relocation decisions. Now let us focus on reassurance. Immigration law in the United States operates under statutory frameworks passed by Congress. Diplomatic disputes do not automatically rewrite those statutes. Agencies may adjust enforcement emphasis. They do not erase legal categories overnight. Your protection lies in compliance. Keep your documents organized, maintain accurate records, update USCIS with address changes using Form AR-11 if required. Monitor case status regularly. Respond to any government notice promptly. Heightened scrutiny rewards those who are prepared. It is also helpful to remember that diplomatic crises often evolve quickly and then stabilize. Consultations can lead to compromise. Governments recalibrate. Agencies return to standard procedures once immediate tensions ease. The key risk during these moments is misinformation. Social media amplifies fear faster than facts. If you hear claims about mass visa cancellations or border closures, verify through official DHS or USCIS communications. Your immigration journey likely took years. It required interviews, fees, documentation, and patience. Protect that investment by staying informed without panicking. If you are unsure whether your travel patterns could raise concerns, review them now. Count days outside the United States, confirm your primary residence documentation, verify your visa validity dates. Small preventive steps today avoid larger problems later. The diplomatic situation between Canada and the United States may dominate headlines, but your daily compliance habits matter more than political rhetoric. Lawful status remains lawful status. Permanent residence remains permanent unless abandoned or revoked for specific legal reasons. Citizenship remains secure, absent fraud. Visas remain valid according to their terms. Global politics may shift. Alliances may strain. Markets may react. But immigration law follows its own procedural channels. Stay steady. Stay organized. Keep copies of everything. Approach each border crossing with clarity. And focus on what you can control: compliance, documentation, and awareness. If you have specific travel patterns, pending applications, or sponsorship situations you are unsure about, reflect carefully on how they align with current regulations. Clarity reduces stress, your legal status is valuable. It is the foundation of your work, your family life, and your future plans in the United States. Protect it calmly, protect it consistently, and stay informed through reliable sources rather than speculation. Uncertainty at the global level does not erase the structure of immigration law. Preparation, documentation, and lawful conduct remain your strongest safeguards.